5 seconds. A bare reading of the above quoted rule makes it clear that periods of service in work charged establishments were not counted as qualifying service. Therefore, the work charge employees had challenged validity of the said rule. The matter was considered by the full bench of Punjab and Haryana High Court. In Kesar Chand vs. State of Punjab and ORS 1988 5 SLR 27, the full bench held that Rule 3.17 of the Punjab Civil Services Rules was violative of Article 14 of the Constitution of India. The full bench decision was challenged before this court by filing a special leave petition which was dismissed. Thus, the ratio laid down by the full bench judgment that any rule which excludes the counting of work charged service of an employee whose services have been regularized subsequently must be held to be bad in law was not disturbed by this court. The distinction made between an employee who was in temporary or officiating service and who was in work charged service as mentioned in Rule 3.17 of the Punjab Civil Services Rules disappeared when the said rule was struck down by the full bench. The effect was that an employee holding substantively a permanent post on that date of his retirement was entitled to count in full as qualifying service the period of service in work charged establishments. The learned counsel for the appellants pointed out the finding recorded by the division bench in the impugned judgment to the effect that we are therefore clearly of the opinion that the work charge service of the appellant with the board must be counted for determining qualifying service for the purpose of pension and argued that the judgment of the High Court should not be construed to mean as giving direction to the appellant to include previous service rendered by the respondent number 1 as work charged employee of the state government for pension purposes. So far as this argument is concerned, it is true that the division bench of the High Court has expressed the above opinion in the impugned judgment. However, the reference to Rule 3.17 of the Punjab Civil Services Rules as well as the full bench decision of the Punjab and Haryana High Court in Kesar Chand vs. State of Punjab and ORS 1988 5 SLR 27 and speaking order dated November 16, 2005 passed by the board rejecting the claim of respondent number 1 makes it abundantly clear that the High Court has directed the appellants to count the period of service rendered by the respondent number 1 in work charged capacity with the state government for determining qualifying service for the purpose of pension. Further, the respondent number 1 has been directed to deposit the amount of employees' contributory fund which we had received from the appellants along with interest as per the directions of the board before the pension is released to him. All these directions indicate that the High Court had come to the conclusion that the period of service rendered by the respondent number 1 in work charge capacity under the state government should be taken into consideration for determining qualifying service for the purpose of pension. Non-mention of such direction in the impugned judgment is merely a slip and the appellants cannot derive any advantage for this.